Good afternoon to everyone and good morning for those of you based in the US. My name is Ricardo Izquierdo. I'm the legal officer for the World Federalist Movement Institute for Global Policy, and I will be moderating today's event. We would like to welcome you to our Global Exchange Conversation Series. The Global Exchange was created to provide a platform for solutions-focused discussions by notable practitioners and experts on major global challenges, such as violent conflict, mass atrocity crimes, pandemics, climate change, among others. Often conversations like this focus on bringing awareness of global issues, but we want to be a little different in that sense, and we want to focus on solution-focused, solution-based discussions, so we can hopefully move forward on these issues. And today we have a very important topic, very relevant and of course very recent topic, and we are joined by a very distinguished panel of experts who are very much aware of this topic and have very interesting views to share with all of us today during the event. Before we get started, just a couple of comments on how the structure of the event today will be. So we're going to split the event in 3 different sections. We're going to touch upon 3 broad issues in those sections, starting by understanding the Trump administration's executive order, its scope, legality, and enforcement. Then we're going to discuss the implications of the executive order on the ICC and international criminal justice as a whole. And lastly, we're going to hear from the experts on what is next. So what can be expected from this development, and what measures can be taken to protect and strengthen the ICC and the Rome Statute system in the face of these sanctions issued by the US. So joining us today, we have Professor Wes Rist. He's the Deputy Executive Director of the American Society of International Law, where he has worked since 2012. At the Society, he supervises the educational programming, including its annual and mid-year meetings, as well as its various interest groups, programs, the Society's signature topics, and general member activities. Wes works on atrocity prevention and international criminal justice issues in the field of international law, having conducted research and training on these and related issues around the world. He co-chairs the implementation committee of the Prevention and Protection Working Group dedicated to US government engagement with NGOs, and he also works with high schools, community organizations, and other public groups to promote public education and outreach about international law. Also joining us today is Professor Michael Sharf. He has been co-dean of the Case Western Reserve University Law School since 2013. He's also the Joseph C. Hostetler BakerHostetler Professor of Law and serves as Managing Director of the Public International Law and Policy Group, a Nobel Peace Prize nominated NGO. He has led USAID-funded transitional justice projects in Uganda, Cote d'Ivoire, Libya, and Turkey. During a sabbatical in 2008, Sharf served as a special assistant to the prosecutor of the Cambodia Genocide Tribunal, and during the Elder Bush and Clinton administration, he served in the office of the legal advisor of the US Department of State, where he held the position of attorney advisor for law enforcement and intelligence, attorney advisor for the United Nations Affairs, and delegate to the United Nations Human Rights Commission. Professor Sharf is the author of over 100 scholarly articles and 19 books, 3 of which have won National Book of the Year honors. Professor Sharf continues to teach in international law and was ranked as among the most cited authors in the field since 2010 by the 2016 and 2019 CISC Leiter studies. Finally, since 2013, Professor Sharf has been the producer and host of Talking Foreign Policy, a radio program broadcast on WCPN 90.3 FM and other NPR affiliates across the US. Last but not least, we have also joining the panel today Professor Milena Sterio. She is the Charles R. Emrick Jr. Calfee, Halter, and Griswold Professor of Law and LLM Programs Director at the Cleveland Marshall College of Law. She specializes in international law and international criminal law, and she has published 6 books and numerous law reviews articles. She holds leadership positions within prominent international law organizations, such as the American Society of International Law, where she co-chaired the International Criminal Law Interest Group, and the Association Internationale de Droit Penal, where she served as U.S. chapter president. Professor Sterio obtained her JD from Cornell Law School, a master in law and a master's degree in private international law from the University of Paris I, Panthéon-Sorbonne, and her BA from Rutgers University. Her latest book, co-authored with Dean Michael Sharf and Professor Paul Williams, was just published with Cambridge University Press, and it examines the impact of the Syrian war on the development of international law. Now, the topic that brings us today to this panel, of course, as you all know, relates to the recently issued executive order by the Trump administration, which authorizes the adoption of sanctions against ICC personnel and their family members, and against the ICC as an institution as a whole. And so in that sense, the idea of today's event is to have a fluent, free discussion on the different topics that we have identified. And we hope to receive also your questions and your comments throughout the event. For that purpose, you can use the Q&A feature that you will find at the low level of your screen to write down your questions, and we will be presenting those questions to the panelists as the event progresses. So without further ado, to start, I would like maybe to focus on the initial section of today's discussion, and that is what is it that we're talking about in relation, so what's going on? The Trump administration has issued an executive order, but what is exactly the scope of the executive order? What does it prohibit? And is it a legal instrument under U.S. law and or under international law? And maybe Professor Rice can start addressing this initial question, and we can hear from the other panelists as well.
Sure. Thank you, Ricardo. It's a pleasure to be with you, and it's great to see Michael and Milena again. I do have to preface with saying that I'm speaking in my personal capacity and not on behalf of the American Society of International Law. So any remarks that I make are in that vein. But I will start us off just by kind of walking through what the structure of this sanctions order, the executive order is, and the sanctions that it involves. And perhaps address a little bit of it before turning over to Milena and Michael, who are quite more the legal experts on this compared to my policy side of things. But the executive order is framed the way it is because it is authorized under IEPA, which for those of our non-American watchers is the International Emergency Economic Powers Act. We're very fond of our acronyms over here, so we shorten that to IEPA. IEPA was something that came out of the good governance movement post-Nixon in U.S. history that was specifically designed to actually limit the ability of the executive to employ sanctions as a tool, requiring that there be certain precursors in place and certain limitations on those precursors in place. So one of the elements of IEPA was that there must be an international or a national emergency declared to trigger the power of these sanctions. That's why you'll notice before we get into, in the executive order text, before it gets into the specific sections, that last paragraph says, I hereby declare a national emergency to deal with that threat. And the threat is supposed to be something to the national security, the foreign policy, or the economy of the United States. This is perhaps one of the biggest things that non-lawyers especially paid attention to when this EO came out, was the idea that the International Criminal Court represents a national security and foreign policy threat to the United States. Just seems like a really difficult thing to accept on the face of it. And there's certainly a lot of questions. The problem is that within the U.S. system, those are not defined. There is no definition of what constitutes a national security threat to those issues, or foreign policy threat, and what rises to the level of a national emergency. And within the U.S. system, our judicial branch gives significant deference to designated executive powers in terms of deciding those things. So there is not going to be, or I shouldn't say that, don't speak in absolutes in this situation, but it is unlikely that there will be a case that can proceed trying to get a judicial authority to overturn this executive order just on a prima facie level. It is worth noting that this is what is referred to as a naked executive order, in that it does not have an appendix of already designated individuals attached to the end. That's not unheard of, but it is unusual. And it's worth noting that what this means is that there is no current set of sanctions that have been implemented against the court or any of its employees or any of the tertiary groups that might be involved with the court under the expansive powers of it here. It would require an affirmative designation by the Secretary of State to add, and the Attorney General, I believe, actually both, to add individuals to that list. They would have to go through the OFAC process, again, acronyms, OFAC, Office of Foreign Asset Control, and the Treasury Department here, which in the United States system governs and administers the sanctions programs that we have. And that list must be made public. It is, by virtue of the sanctions regime in place, you can't implement and obey with the sanctions if the people don't know who they're not supposed to be doing business with. So if there is any movement on this, the administration will have to make public that list. And it does go through a process to be approved to be added to that. And so there is a procedural element that would have to take place before individuals or entities may be added. Let me pause there. Michael, Milena, anything to jump on top of with that? Because I know this is not a common thing for non-US people to be aware of.
Maybe I'll jump in at this point. So the executive order, as Wes said, is a first step. But what it does is it authorizes three different things. One is called blocking. And blocking is, in essence, the freezing of all assets. The second one is material support. And that includes giving any advice or assistance to the International Criminal Court. And what's interesting is there is a U.S. Supreme Court decision from a couple of years ago that says that when lawyers give advice, that is not protected by the First Amendment from a blocking or a freezing order under IEPA. And so without getting a license from OFAC, which is not an easy thing to do, this means that U.S. academics and lawyers can no longer support the International Criminal Court, which presumably means all those amicus briefs that we've been submitting and the work that my students in the War Crimes Research Lab has been providing, that all has to end because of this. And then the third thing is it specifically has exclusion of visas to, again, people who would be named, but it means that the people from the ICC will not be able to travel to the United States to participate in all the conferences that we do. The one thing that they probably would still be able to do, at least Fatou Bensouda, the chief prosecutor, is come to the UN and make her annual report, because there is the UN headquarters agreement which supersedes these kinds of things. It's an international agreement that gives people who are invited to the UN the specific right to come under any circumstances. But otherwise, those are the three consequences. And the one to me that is most disconcerting is the material support, because it is so broad.
And Ricardo, I would just add, thank you, Michael and Wes. They're absolutely correct. I would just emphasize on the visa issue. The executive order is so broad that it basically allows the United States Secretary of State to deny visas not just to ICC staffers who are working on investigations into U.S. personnel and our allies, but also their family members. So basically, if Fatou Bensouda's brother, if she has a brother, wanted to come to the United States, the U.S. Secretary of State could actually deny visas to her family members. The executive order also, by the way, allows the U.S. to deny visas to the United States to any ICC staffer, even those not working on the Afghanistan investigation or some other investigation into the United States. So again, incredibly broad. And then last, but certainly not least, as Michael mentioned, not the most troubling aspect, but certainly a very troubling aspect is the fact that there are these tertiary individuals, as Wes mentioned, all of us providing all sorts of support to the court, if you will, that are now at risk for sanctions and might have to cease doing things like filing amicus briefs or allowing our students to work as interns at the court, or even working in clinics that are based entirely in the U.S. And then last thing that I would just mention is how did we get here? To those who have followed the Trump administration moves, this is not a surprise. This is basically in direct response to the ICC appeals chamber's decision from a few months ago, from March of 2020, in which the appeals chamber overturned a prior ruling by a pretrial chamber and essentially authorized the Office of the Prosecutor to proceed with the Afghanistan investigation. So this is in direct response to the appeals chamber ruling in March.
And I jump in to emphasize that, that question about what does the support look like here is a very nebulous one, and one that is yet to be defined and is rather troubling. I see in the chat someone posted, what does this mean for Americans? Americans cannot be directly targeted by the sanctions. That's an IEPA provision. But they will face penalties and fines if they violate the terms of the order. And this is one of the reasons why the effects of this are so widespread and concerning, is that at the point where an individual sanction against a sanction against an individual is put into place, or a sanction against the entire organization, I think Michael mentioned, it could be the International Criminal Court as a whole. That is within the ambit of this. They could just decide the entirety of the court would be sanctioned. Once that happens, the implications for especially U.S. businesses become significant, and even non-U.S. based persons or people who don't come to America regularly, so the travel ban is not the visa restriction is not a big deal to them. Maybe all of their money is in European bank accounts. But if they transfer that money, or if they make a payment to anyone, odds are that that money digitally is going to flow through a U.S. service provider of some kind. If they've got a Visa or a MasterCard, that account is going to have to be suspended or blocked, as Michael used the correct terminology there. The knock-on effects of this are quite large in the interconnected and highly digitally dependent world that we live in, where the U.S. financial system plays a central role to non-U.S. transactions, to things that happen around the world. There's just almost always a U.S. element that is involved. And it's also worth noting that private actors tend to be very, very concerned. This is known as the chilling effect. They tend to be very concerned about violating these because the corporate liability there, the penalties can be quite steep. So they often go out of their way to avoid anything that could come even close to a potential violation, meaning that even further service reductions and access is prohibited to the individuals who might eventually be sanctioned. So it's challenging.
To follow up very briefly on that point, this is why folks have already, like, if you are actually someone who has been named by the U.S. government as a sanctioned person, people have referred to that as that's your civil death.
Civil death.
So you're not murdered, physically, but it's the equivalent of a civil death because of all the restrictions you're going to have. Basically, for example, you're not going to be able to use your MasterCard. Those seem like minor details, but literally, you risk having your financial freedom. I would say is completely undermined.
if I may, we are receiving some comments which I think are fundamental now for this section, especially of the webinar. And one of those is, can Trump's action be justified by placing these sanctions into place? And so, and maybe to address that question, how can it be understood that the U.S. considers the ICC as a threat to national security? And where does that come from? And is there validity in the argument that the ICC cannot exercise jurisdiction over U.S. nationals because the U.S. has not ratified the Rome Statute? Maybe Professor Sharf, I understand you've had experience on this, and maybe
so, you know, this argument goes back 22 years. In 1998, the week after the Rome Conference was concluded and the treaty establishing the ICC was finalized, I was asked to testify at the U.S. Senate Foreign Relations Committee. And the other two experts were John Bolton, who you've seen a lot in the press these days, who was absolutely against the International Criminal Court. And he was then a proponent of what became the American Service Members Protection Act, which was, you know, something that was even more extensive than this executive order. It literally had a clause that said that if an American was ever caught and surrendered to The Hague, that the U.S. would have to do everything within its power to get that person released. And the critics of this act started calling it the Hague Invasion Act, which, you know, I think was not all that far-fetched. One of the things that that act also did is said that any country that ratified the ICC would have all of its foreign assistance from the United States automatically cut off unless the president specifically waived that. And the big concern was there were a lot of countries that ended up ratifying the ICC statute that the U.S. was giving anti-narcotics assistance to. These are the countries in Central America and Latin America where they were fighting against drug cartels. And all of a sudden, all of that assistance would have been pulled away from them if they ratified the ICC statute. And in fact, every one of those countries did ratify the ICC statute. The funny thing about this act is it didn't stop anything. And literally, it only had a negative consequence to the United States, not to the other countries or to the ICC. And some of the presidents have waived that provision and some of the presidents have not. But this, Ricardo, I'm sorry, the idea that the ICC could not exercise jurisdiction over non-party states, which is at the heart of the U.S. argument, that actually starts out with Ambassador David Sheffer. So he's testifying there before the Senate, and he says that the Vienna Convention on the Law of Treaties, which all of your international law professors and students and practitioners are well familiar with, it says that a treaty cannot have an effect and it cannot be binding on non-parties. That's like rule number one, the first commandment of international treaty law. And so he claimed that the ICC in its Article 12 that said that it has jurisdiction over non-parties and their nationals when they commit crimes within the territory of the parties violated the Vienna Convention. He's the one who planted that. What's really interesting is he argued as an amicus back in March before the appeals chamber on the Afghanistan case that was wrong. He says he's seen the light, and that is the dumbest argument that has ever been made, and it has no legal basis. And he's the one who started that argument. And he would be the first to say that he regrets that he did. And he doesn't really say, well, I was paid by the U.S. government to make that argument. He just says he's had a change of mind as he's learned more. But it's unfortunate because that argument was pernicious. The argument finds itself being quoted in the American Service Members Protection Act. So the U.S. Congress has adopted it. And it has been the U.S. policy for these 22 years that the ICC should not be able to exercise jurisdiction over the nationals of non-party states. Now, here's why the argument is dumb, according to Ambassador Sheffer and almost everybody who has looked at it, and it's this. When a national from a country commits crimes in another country, they are subjected to the laws of the other country. And the U.S. will even extradite its own nationals when they commit murder or drug offenses abroad in other countries. And they don't care whether they have jury trials. They don't care whether they have all the due process obligations and requirements of the United States. They just will extradite, because it's always been the case that if your nationals commit crimes abroad, they are subject to the jurisdiction of that country. Well, the ICC is based on a delegation of authority to prosecute. So if these countries have, like Afghanistan, has the authority to prosecute Americans who commit torture or war crimes in Afghanistan, then Afghanistan also has the right to delegate that to an international criminal court. And the flaw in the argument is it's not the U.S. that's being prosecuted for these crimes. It's nationals. And there's nothing unique about that other than the fact that it's been delegated to an international court rather than being domestically prosecuted. And so there is no violation of the Vienna Convention in the minds of almost everybody who's looked at it. And therefore, the entire U.S. principle here is based on sort of a bankrupt argument that Ambassador Sheffer is very sorry that he ever made.
It's also, I want to jump in here because it's also worth noting that this entire exercise is also only happening as a way for the United States administration, and in this situation, both parties have been in power with administrations that have refused to make the choice to hold accountable its own citizens for actions that are potentially implicated by the Rome Statute. As many of our audience know, the Rome Statute is based on the principle of complementarity. This was a big argument that the United States worked hard to introduce into the Rome Statute. It was an American principle to say, you gotta give the local and national governments first crack. They've gotta have the right to prosecute and investigate first. And all that would have to happen, and I say all because in the American political context, this is a huge deal, but all that would have to happen is that the United States needs to open a legitimate investigation into the allegations of wrongdoing, specifically torture, that happened in Afghanistan by its actors or by employees that it sanctioned in that time period. And we don't even have to have a trial. Like, I mean, in the interest of justice and as someone who wants to see accountability, I want to see that happen. But the reality is that under the legal arguments or under the legal precedent in the Rome Statute, conducting an investigation into the allegations here and issuing a finding would be enough to bar movement by the prosecutor on this. It would trigger complementarity, and that would be the political easy solution. This would, I'm not advocating this, but the easy way to do it would be to have a politicized investigation that's never going to hold people accountable that, you know, you would want to, but you can check that box off and perform that, and it would probably remove that. It is the lack of America's willingness to engage in internal accountability exercises that is causing this to begin with, and this executive order, in my opinion, is a further attempt to try and avoid having the conversation about the fact that the United States performed reprehensible acts at that period in time in Afghanistan and in other related places.
And Ricardo, I would just emphasize 2 points already made and just and make a third one. One, you know, Dean Sharf already mentioned, you know, this idea that American citizens are somehow immune from prosecution anywhere else in the world. That is just not true. As Dean Sharf mentioned, American citizens can be prosecuted in other nations, right? So why not in an international court? Two, as Wes Rist mentioned, the principle of complementarity within the Rome Statute structure, it actually works for non-state parties as well. So Article 18 of the Rome Statute allows both state and non-state parties to put in so-called deferral requests with the court, where you actually ask the court to pause, suspend an investigation, where you make a complementarity-based argument where you say, we're actually going to investigate this. That mechanism is actually also open to non-state parties. So the United States could put in an Article 18 deferral to the ICC. Now, that also would be politically extremely difficult right now, because that would actually require the Trump administration to acknowledge the legitimacy of the Rome Statute system, right? Which I don't think is going to happen, but it would be, I think, relatively easy, as Wes said, and to be extremely cynical about it, you actually could open a bogus investigation. I'm not advocating that this be done, right? But that's all you really need to do if you want to actually pause the ICC investigation. And then my third point is just going to be about the legality of the executive order under domestic law. And Rist already mentioned this. Unfortunately, while I think we all agree that this is a really bad move, this is a really bad policy decision, under domestic law here in the United States, I think that this is actually legal, because AIPA, the statute that Wes mentioned, allows our presidents to do this. All they have to do is declare that there is a threat to the United States. And courts are extremely deferential to presidents here. Now, under AIPA, the president also, by the way, has to inform the Congress that this is what he or she is doing, but Congress has no authority to override the president. So Congress can't do anything about it, and judges, the judicial branch, is very unlikely to do anything about it. And so, unfortunately, I think under domestic law, if there were an attack on this, I think that this executive order would stand. I'm not saying it's a good idea. It's certainly bad policy, but I don't think it would. I don't think it would be overturned.
It is worth noting that it does have to be renewed each year. Yeah. So it does have an automatic sunset clause. And obviously the 1 year from now is going to be post a November election. So there may be political changes that would implicate this. But speaking in the current administration, the current administration could just renew this each year automatically.
So, Les, you think that this is really just a unique Trumpism phenomenon? Let me just take a 30,000-foot view of the politics between the United States and the International Criminal Court from the beginning. So when President Clinton, who was a Democrat, was in office, that's when we negotiated the ICC statute. And President Clinton's executive branch wanted a Security Council-controlled International Criminal Court. That's what they were trying to accomplish. And when they failed to accomplish that, Ambassador Schaeffer, who I mentioned before, who was the head of the negotiating delegation in Rome, he said, this is not a good court because you opened it up too broadly, and there's going to be like an international version of Ken Starr, who was the special prosecutor in the U.S. who investigated Bill Clinton, and that's what they were scared of. All right, but notwithstanding that, in the last days of office, Bill Clinton sent Dave Schaeffer up to sign the ICC statute. Now, then you get George Bush Jr., who comes into office, and in his first week, he sends John Bolton up to New York to unsign the ICC statute. And the reason he did that is because Article 16 of the Vienna Convention of the Law Treaties says that if you have signed a treaty but you have not yet ratified it, you cannot take actions against its object and purpose. And the Bush administration wanted to take action against the object and purpose. They literally wanted to declare war on the ICC. They wanted to squash it so it never came about. And therefore, that's why they supported this thing called the American Service Members Protection Act, which also is sometimes referred to as the Hague Invasion Act. Now, the Obama administration comes in, and they, were somewhat supportive of the ICC. They were supportive of a Security Council referral of the Darfur situation in the Sudan, which involved a non-party state going to the ICC. But I guess that's unique because the Security Council sent it, and that's consistent with the U.S. initial idea. And then you have the Trump administration come in, and what's interesting is they were pretty quiet during the Myanmar Bangladesh proceedings last year. And that's a case where the Bangladesh military and paramilitaries were committing genocidal acts and crimes against humanity against a minority group called the Rohingya.
The Myanmar.
What?
The Myanmar military, not the Bangladeshi military.
Oh, yes. I'm sorry. I got the cart ahead of the horse there. Yes, the Myanmar or the Burma government and paramilitaries in Myanmar were committing these atrocities against the Rohingya. And as part of that, they were forcing them out to Bangladesh. That's where Bangladesh comes in. And the Bangladesh is a party to the ICC statute, but Myanmar was not. And so Bangladesh says, look, there are crimes that started in Myanmar, ended up in Bangladesh. We are invoking the jurisdiction of the ICC. In November, the ICC decided that it did have jurisdiction over nationals of a non-party state, Myanmar. And the Trump administration didn't say anything. Crickets, right? That's what we say in America when there's like no sound at all, but the sound of crickets in the background. So that seems to me to be inconsistent with suddenly they woke up and said, oh, it is not allowed for the ICC to prosecute nationals of a non-party state because they were perfectly happy about it when it was Myanmar. So that seems inconsistent to me.
How can that duality be explained? Because Wes mentioned the contributions that the U.S. made in the drafting of the statute and very clear provisions of the statute, particularly regarding complementarity. But also Professor Milena just explained that, well, it would be unlikely to see the U.S. activating Article 18, given that that would give legitimacy to the court, correct? But at the same time, we've heard from you, Professor Sharf, that, well, the U.S., and we know that the U.S. has had an active role in international criminal justice, from Nuremberg to Yugoslavia, and then supporting or at least not objecting the referrals of to the ICC of the Darfur situation and the Libya situation. So how is that? How can those two positions be reconciled?
Because our foreign policy is not required to be internally consistent. I mean, the United States government operates foreign policy based on the political decisions of the executive branch, not based on just an understanding of law. It is certainly an important part of it. International law is a relevant question. And we have the legal advisor's office in the State Department where Michael worked and many of my colleagues have worked over the years. But American foreign policy is open to political elements, and the president has significant broad power on how to implement U.S. foreign policy. That's why oftentimes there are discussions of the pendulum swings that happen between administrations in the U.S. government on American foreign policy. So I think that's baked into our system, Ricardo.
There was a book by Jack Goldsmith that said that the pendulum doesn't really swing all that far. And part of the theme that has been consistent, I think, in the last 20 years between both Democrats and Republicans has been the theme of American exceptionalism. Yeah. That is a foreign policy that has actually been embraced largely by Republicans, but to a lesser extent also by Democrats. And here's an example. So Milena was saying that the U.S. could protect itself from Afghanistan through complementarity by prosecuting the people who committed torture. But during the George Bush administration, the United States began the waterboarding, and they had the White House torture memos that said that you could do basically anything, extraordinary measures of interrogation to get information from Al-Qaeda to protect the United States from a future attack. And when the Obama administration came in, there was great hope that not only would he stop it, which he did, he had his own executive order and said, stop doing that, but that he would prosecute the people who were responsible. And he said something very interesting. He said, look, I want to be like Nelson Mandela and South Africa. I think the country needs to get past this. We're not going to prosecute those people. We're going to look forward, not back. And that's a horrible thing from the point of view of international justice, because it sends all the wrong signals. It sends the signal that you can get away with it. What we're committed to in the world of international justice is that prosecution is persistent and patient. You commit a crime 30 years ago, you might end up today being prosecuted at the Cambodia Tribunal. You commit a crime 70 years ago, you might end up being prosecuted today in the courts of Germany for being a concentration camp guard or something in World War II. It doesn't forget, and it does prosecute, and that was not the policy of the Obama administration. And I do want to point that out because that's part of the problem here. We will not see the U.S. exercise complementarity. They will not prosecute the CIA members that were involved in creating black sites, that were involved in these acts of torture in Afghanistan, but nor did the Obama administration want to prosecute them. And so it's been a problem that has been not just a Republican or a Trump problem. It has been, you know, both administrations.
And Michael, I would just add on that point that while the idea of complementarity sounds perhaps really good in theory, I would, you know, caution us that, you know, if you really believe in international criminal justice and if you believe in accountability, I would argue that any time a country is in a position where it's supposed to prosecute, investigate, and prosecute itself, it very rarely results in meaningful convictions, if you will. And look at, for example, the United Kingdom, which for the past 5 years has been looking into cases of, you know, potential UK troops committed atrocities in Iraq. Nothing so far, right? Out of thousands of potential cases, nothing has come to fruition so far. And then the second point I would just make, going back to your original question about, you know, sort of how is the U.S. now not supporting the court, but it had perhaps, you know, participated in the room negotiations and it had supported other tribunals. I would say that from a U.S. foreign policy perspective, it is a very different proposition to say that we're going to support the ICTY, you know, the Yugoslavia Tribunal or the Rwanda Tribunal. Those tribunals are investigating atrocities that occurred there. There's really zero potential that the United States is somehow going to be implicated. It is.
Oh, but you know what? Let me just interject on that for a second. There is a situation that happened in the former Yugoslavia that I think affected the entire U.S. approach here, and this is what it was. 1999, the NATO countries decide to start bombing Serbia to get them to stop doing atrocities against the Kosovar Albanians, and during that 86-day bombing campaign, the bombs started to go astray. They were hitting civilian targets. They were hitting the embassy of China in Serbia. They hit bridges, which were cultural targets. I mean, there were a lot of bad things happening during the bombing campaign. So a bunch of scholars from Osgood Hall, which happened to be the school that Louise Arbour, the chief prosecutor of the Yugoslavia Tribunal, was from, they filed a brief before her tribunal saying, you need to open an investigation and potentially indict the NATO countries and the officers for these war crimes. And they add things like using cluster bombs and depleted uranium munitions, and they threw, you know, everything at this. Now, at that very moment, Ambassador Sheffer, who I mentioned before, he goes up to the ICTY, the Yugoslavia Tribunal, and he hands Louise Arbour this box of intercepts and materials about Slobodan Milosevic. And he says, you need to indict Slobodan Milosevic. If he's indicted, he will stop and, you know, the war, and he will agree to Kosovo's you know, ultimate, it's now, you know, basically quasi-independent, and it's a protectorate of the UN, and he'll agree to all of that if you indict him. But if you indict NATO, the NATO countries are going to stop the bombing campaign, and Serbia's Milosevic will win, and then he throws this in. It might kill NATO completely, because it'd be such an embarrassment, NATO could collapse. All right, so this was a moment involving the Yugoslavia Tribunal that the U.S. was involved in creating because it was created through the Security Council. But at the time it was created, the U.S. didn't know that it was going to be involved in a bombing campaign in, you know, one of the former Yugoslavia countries. It had subjected itself to the court's jurisdiction. And it realized that these courts could have a huge effect on American foreign policy. I mean, it could kill NATO, huge effect. I think that that was the moment that scared the, you know, first the military and then the national security, and then, you know, hardened a lot of U.S. opposition against international tribunals because they got scared of them, even the ones that were created by the Security Council. And that's part of the history here as well.
If I may now maybe direct the panel to discussing what will be the implications of this situation. Is it fair to say that this will be the end of the court? Because, well, Professor Sharf already mentioned how far-reaching the consequences of the executive order may be. And so we're talking about freezing of assets. We're talking about material support not being able to be provided anymore to the court, and then the issue of the visas. And so this can have implications not only for the court and for the family members of ICC staffers, but also for foundations, for civil society organizations. So what can we expect the extent of this executive order to be for the future of the ICC and for the future of international criminal justice as a whole?
I'm happy to jump in. Let's go, Milena. Go ahead.
Sure. So I'll be brief. Well, first of all, I hope that it's not the end of the court. You know, I think that we're presenting to an audience of folks who are hopefully, positively oriented towards the court. The court was such a huge accomplishment in and of itself, and I really hope that it's not the end of the court. But, and then the other thing that Wes mentioned, keep in mind that in November of this year, we have a presidential election here in the United States. And actually, the most optimism that I have is that, we will have a different outcome at that election, and a new president could certainly overturn the existing executive order. And the existing executive order, by the way, by some political pundits here in the United States, has been analyzed as basically a pre-election move. That President Trump is trying to drum up support, among his base. His base is definitely not international justice minded. And so it might be that the executive order continues to be naked, as we say. Nobody's named. It exists. President Trump can say to his supporters, I did something, I hate the ICC, I'm trying to block all of this, but it doesn't actually become implemented. And one other point on that is that when the executive order was actually announced here in the United States earlier in June, the Secretary of the Treasury Department, Steven Mnuchin, was actually not present at the press conference when this executive order was announced. And some have interpreted that as very significant because the Treasury Department is actually the department that implements the sanctions regime. It's the Secretary of State that gets to designate, according to this EO executive order, as to who is supposed to be named on this list, but then it's the Treasury Department that implements. The Treasury Department chief, the secretary, was not present at this conference. So maybe this won't actually be implemented. If it is implemented, it could pose significant obstacles to the court. And just to name an example, because basically so many financial transactions are conducted through U.S. markets in U.S. dollars, U.S.-based banks and other financial entities would be obligated, if this order is implemented, U.S. banks and financial entities would be obligated to actually freeze, the assets coming through the United States. And as Wes Rist already mentioned, there's a very significant penalty regime in place here in the United States for banks and institutions that don't implement the order. And so there's a high likelihood that financial institutions in the United States would actually comply with the order. And so what that might mean for the ICC is that, for example, it has to significantly change how it pays people. What if the salaries, the way that they're paid, maybe not for all, but for some staffers, actually go through U.S. financial institutions? For example, that would have to be changed. So I don't think it would mean the death of the court, but I think it would pose significant hurdles to the court.
And again, I'll put this in a big picture perspective. The ICC has had a tough couple of years. First of all, you had a whole bunch of African countries feeling that it was Africa-centric. It was a bunch of Europeans focused on prosecuting and trying a bunch of Africans. And so you did have some African countries withdraw from the court. You had a lot of African countries that allowed an indicted person who was accused of genocide, al-Bashir, the president of the Sudan, to come to their countries as honored guests and not lift a finger to bring him into justice and surrender him to The Hague. So that was the first problem. Then you had a bunch of very high-profile cases that fell apart and resulted in acquittals. And that was very embarrassing for the court. And there are now studies being done to see, what should have been done differently and how could the court be made more efficient. And then you have this as the latest blow to the court. It's a tough couple of years. There are those who think that the ICC is in the situation of the League of Nations and that it will collapse and be replaced someday by a new, better International Criminal Court. I do not believe that's the case. I actually think that the ICC is more resilient than its critics believe. And you see this in terms of in Africa, when several countries, including South Africa, tried to withdraw, the NGO community, the civil society, they came in mass, pushed back hard. And the African countries have continued to support the ICC. And you see this, when the United States earlier tried to keep countries from ratifying the ICC statute by saying, we'll cut off our financial aid to you. They ratified anyway. And now the ICC is starting to get a little wind in its sail because al-Bashir, the president of the Sudan, who I mentioned before, was accused of genocide in Darfur. He's fallen from power, and his country said they were going to surrender him to the ICC. And just a couple of months ago, a leader of the militia that was committing the genocide in Darfur, as his proxy, was surrendered to the ICC. And these things are positive steps. And I'll say something a little cynical, but I think that the Trump administration trying to wage war against the ICC may actually support the ICC. It may help the ICC. And I'll tell you this in terms of history. When the United States lost the Nicaragua case before the International Court of Justice in 1986, and the United States said, we are so mad that the International Court of Justice has ruled against us for the first time, and didn't embrace our jurisdictional arguments, so we're going to pull out of the compulsory jurisdiction. That actually triggered a whole bunch of countries around the world to join the compulsory jurisdiction of the International Court of Justice. That was, a lot of people say, the year, the ICJ went from being a fledgling institution to a really strong court for the world that still exists today after 75 years. And I don't think that we're seeing a League of Nations moment. I think we might be seeing a 1986 Nicaragua moment. And I like to think that Wes is right, that there might be a change of administrations. A new administration will come back and be more supportive of the ICC. I don't believe that the U.S. is going to suddenly embrace the ICC in total. The kind of propaganda that we've had in the U.S. for 20 years against the ICC has really been enshrined in public opinion. It'd be hard to reverse that very quickly. It's going to take years to do that. But I don't think that this is the death knell of the ICC. I think that this might actually be the thing that props the ICC and gives it, more credibility around the world.
So let me follow up on both of those excellent, points and point to some more practical elements. Milena touched on this a bit, but I would flag if the ICC itself were to be put onto the list as a sanctioned entity, one impact would be no American can work for it. Automatically at that point. It would be a violation of U.S. law for an American to work for the International Criminal Court. So there's going to be an impact there. Now, there are a limited number of Americans working directly for the court because the court emphasizes state party employees. So, it's not like many of the other international tribunals where there's a large number of American lawyers there, but there are certainly important ones, and I think all three of us know many of those folks in those positions. This would be a heart-wrenching thing for them. There's also this very nebulous question of what does support mean beyond the amicus briefs that Michael so rightly pointed out and the additional input that those provide. There are numerous NGOs around the world that provide support to the court, either in victim support, in investigation, in reporting out of countries, in providing evidence or directing them towards evidence that the court can use. The court is doing better on victim support, but it is not there yet, and it relies quite heavily on NGOs to assist with that. And it does not have the capacity to conduct the kind of investigations that NGOs dedicated to certain parts of the world or even to single countries or single conflicts can do. And that information can be incredibly valuable. And there's a decent chance that any American working for any of those NGOs, any donors to any of those NGOs that are American, or any money that flows through America in our complicated financial system would be prohibited and would not be allowed to move One thing I do think it's worth mentioning, and I am not an expert on European finance, however, it is worth noting that the EU does have its own blocking statute, specifically in place to challenge U.S. sanctions regimes on things where the European Union has a different foreign policy perspective. This has specifically been used with Iran and Cuba, where the EU maintains relations and has ongoing activities. Certainly the fact that the European Union came out quite strongly in support of the ICC after the executive order by the president indicates that I think there is still certainly a depleted but present level of goodwill and support for the court that exists in the European Union. And nor, given my understanding, and I'm not a finance guy, nor does the EU financial system compete in a global sense with the US, but it does offer potentially a way for finances to be moved around without being in violation of IEPA if the EU were to decide to apply the blocking statute in this situation. And that is not, to my knowledge, that has not happened yet, but it is certainly a tool in the toolbox that might be deployed to potentially mitigate should there ever be individuals put on that sanctions list. The other thing I do want to mention of what does this mean is the U.S. has been engaging on, and this is the policy stuff that I work on specifically, on things related to atrocity prevention writ large. And we've seen this in specific legislation like the Elie Wiesel Genocide and Atrocity Prevention Act, as well as the recently passed Global Fragility Act, which is not as recent as I was thinking because it's now July, or almost July. So that was passed at the end of last year. Both of those address prevention as critical tools, and obviously the Elie Wiesel specifically addresses atrocity prevention. Both of those address transitional justice mechanisms and international justice. And I was privileged in early June to author the recommendations from the NGO community, the Prevention and Protection Working Group that we submitted to the State Department and the National Security Council on what should the next steps on atrocity prevention under Elie Wiesel be. And they included a specific call out of the International Criminal Court as well as international justice mechanisms writ large. We did not know that a week later this executive order was going to be coming out and basically putting that at odds. But there is legislation on the books that supports international justice writ large. And now the U.S. does have legal obligations in tension here. And I think there's going to be interesting questions asked by Congress, especially by the House, specifically about how is this supposed to work? How is the United States supposed to support international justice and atrocity prevention on one hand, while tearing out the foundations of the largest international court for atrocity violations on the other? And so I think there are policy issues that are going to be ongoing here. I don't know how they're going to resolve, and I don't know what the responses are going to be from the different branches of government that we have in play. But I think it is worth noting, as you questioned, Ricardo, as to what happens going forward and what does this all mean. These conversations are going to be happening, and there's going to be, I think, an internal evaluation of how the U.S. government responds to this too.
And Ricardo, if I just made one quick point that I would just add, just following up on Wes's point, I think this is precisely why I would argue that this is such bad policy for the United States, because this will now basically undermine the existing relationship between the U.S. and the EU. Imagine if the EU, if the U.S. starts naming individuals for this EO, and then the EU invokes its blocking statute. Now we're at this, diplomatic war with the EU, and the U.S. actually benefits from EU support on various initiatives, including transitional justice, but including also things like counterterrorism, sort of eradicating weapons of mass destruction. There are lots of other issues on which the United States benefits and has benefited from EU support. And now, because of this anti-ICC move, we risk essentially losing EU support on all those other initiatives, when in reality, if the US truly wanted to simply suspend the Afghanistan investigation, all it needed to do was to invoke the complementarity provisions in the Rome statute and say, we're looking into this. And that would have been the end of it.
Thank you all. These are all very, very interesting points. And I hear already that we are discussing, well, some of the ways, some of the measures that could be taken to protect the court. And so Professor Sharf, for instance, is putting forward the case that this situation might actually strengthen the court. And so one of the questions that we have received from the audience is whether the executive order can be challenged by U.S. agents, so domestically. But also, and I would add, if the situation can strengthen the court, what would need to happen for that to be the case? Given that, well, the executive order could impact the way the court carries out an investigation, even how ICC staff gets paid, as we have heard. So we know that the EU could support the court by implementing the blocking statute, but what other measures could or should be taken in order to protect the court and so that this doesn't ultimately result in the court collapsing because of these measures?
Let me start with the first half of the question about challenging the executive order in U.S. court. So you have to try to figure out what is the right vehicle, what is the right case to do that. And one type of case might be where a lawyer in the U.S., a law professor, law school, is providing legal research assistance to the ICC, doing amicus briefs or writing memos and so forth. And then suddenly the executive order is trying to seize the resources of Case Western Reserve University School of Law. Okay, like that, and to my trustees, we're not going to test that. Don't worry about it. But anyway, let's say that goes up. And then there's a case where it's, it could be about what are the rights of American citizens that are trying to exercise, First Amendment rights. And it might be a more clear case than the one that was tested by the Supreme Court involving a terrorist organization. But even there, I think it's a tough one to win. And I think, the other kinds of cases, the immigration cases or the cases of the prosecutor's assets, those are even harder to win. And here's why. The controlling legal standard in the U.S. is called Youngstown Sheet. That's the name of a Supreme Court case. And there, ironically, Robert Jackson, the same guy who was the Nuremberg prosecutor, he writes a concurrence that now everybody uses as the legal standard in the U.S. in this type of case. He says, when you look at an executive action, you have to decide whether the action is with congressional support, against congressional support, or Congress is silent. If it's with congressional support, the Supreme Court almost always will defer to the executive action in foreign policy. And that's the case of this because of IEPA. It's a congressional statute that is supporting what the executive is doing. The executive has invoked all the right language. And even though it's really pretty outlandish to think that the ICC is the same kind of national security threat that drug traffickers are, or that North Korea is, or that the Iranian Scud group is, to think of the ICC in that basket is really a stretch. But I don't think the courts will challenge that. And then, of course, the next one is where Congress has opposed it. And I don't think that the Elie Wiesel statute is clear enough to be read as in opposition with IEPA and with this executive order. And then this isn't a situation where the Congress has been silent. So if I'd have to guess, I'd have to say that the executive branch will prevail if this is tested in the U.S. And also, you want something that happens pretty quickly, and it has to go from the district courts, the appellate courts, and ultimately to the Supreme Court, and that's not going to happen before the election. So, if there is a change of administrations and the executive order is not renewed, that would sort of counsel for let's not test it now, let's wait.
Yeah, I'd like to point out, if folks haven't read Opinio Juris has a two-part piece by Andrew Boyle, who's actually co-chair of the International Criminal Law Interest Group, or maybe a former. I forget if he still is. Sorry, Andrew.
He's co-chair. He's co-chair.
Okay. So he did a great breakdown of a lot of these elements, and then Just Security did I don't know, there's like 6 or 7 articles out there specifically looking at this. Those are all worth your time reading. They're all from different perspectives. They're addressing different elements of it. They are absolutely worth your time to dive in on this a little bit. One of the things that came out from many of those is, because this is a naked order, because there are not sanctions yet in place, none of this has yet been triggered. And as Milena said, there is an argument to be made there that this was absolutely a political move. It was putting another arrow in the quiver of things that President Trump could say to the people that he is appealing to for their votes about how he is against this kind of thing, and that seems to align with what they agree with for foreign policy. It is worth pointing out that it takes time to put people on the list. It is not just snap your fingers and they appear. There does have to be a review by Treasury of going through. And we are, July, August, September, October. We're 4 months out now. Every day that goes by makes it more difficult for those sanctions to be put in place before the election takes place. Again, speaking in my personal capacity, were Ambassador Bolton still in office, I would be far more concerned than I am perhaps right now about the high-profile nature of this and the importance. But maybe let's put it this way. I would be far more concerned that this was much higher on the priority list of individuals within the administration than I think it is now. But we're guessing. Like, this is absolutely standing from the outside. I don't have, insight into what the political decision makers at that level are thinking. So it is still potential, and it is a risk. And I think the court does unfortunately need to be thinking about how it responds to this, which is a travesty in and of itself, that it wastes its time and its resources having to address this instead of going after the worst violators and prosecutors. But I do tend to find myself optimistic, along with Michael, that this could be a moment where the court pivots and rallies support behind it and moves forward. But the court is going to have to affirmatively work at that. It is not enough just to say, throw up its hands and say, look at how mean the United States is being. You should all be on our side now. There are real problems with the court, and there are real issues that they need to address and things that they need to fix. And there's a bunch of efforts going on right now to try and evaluate those. The Assembly States Party is coming up. There's going to be efforts there. I think the court needs to aggressively use this as a moment to build, to address concerns that existed. Michael went through a whole litany of things it's been a tough couple of years for the court and for the court supporters. The court can't be passive here. It needs to move things forward, and it needs to demonstrate a willingness to continually improve. And I think that's a critical part of this. None of us should expect that the court is in its most perfect form now. Like, this is an experiment that has succeeded in many ways and has exposed failures as well. And we tweak it and we get better at it. And you change the nature of the experiment in order to address the things that have gone wrong, and you do better going forward. They're going to take on that moment that Michael highlighted. I think the court has to affirmatively take that role on.
And let me add something that I forgot about till you were just mentioning this, Wes. The court's first cut at this issue was the pretrial chamber's 2-1 decision to dismiss the investigation in the interest of justice. Yeah. And that engendered so much criticism because the court was accused of just kowtowing to the United States and not applying a legal standard. And so when the appeals chamber re-looked at this and decided 5-0 that there was jurisdiction to proceed, I think that was seen as a good moment for the court by its supporters, because the court was doing what was right, and they were saying, we're going to do what's right even if it makes the United States angry. And that made a lot of other countries say, well, then this court is more of a legitimate institution than we thought. And that's partly why I think this is a good moment for the court.
And let me, Ricardo, let me mention, following up, I absolutely agree with Wes and with Michael that, this might be the moment that the court actually sort of regain some of its lost legitimacy, perhaps. For the record, I was always a supporter of the court. I always thought that it was doing sort of as best as it could under the circumstances, but its legitimacy has been under attack. There is an ongoing ICC review process. So last fall, late in 2019, there was an official review process that was launched, and several prominent experts were named to this review committee. It's chaired by Justice Richard Goldstone, who we all know, a very prominent figure in this world of international criminal justice. The experts already met once in January in person while it was possible to still meet in person, but the review remains ongoing. And the review will basically entail things like reviewing improvements to the judiciary, improvements to the office of the prosecutor, improvements in terms of the court's efficiency. So I think that the court could actually use this moment and use the ongoing review process to actually re-emphasize its own legitimacy and to say, look, we've been listening to the criticism, and here's how we're going to improve things in the future, and here's why we remain legitimate and important. And then, Wes already mentioned, the U.S. election is looming extremely large over all of this. This executive order, I think Wes is right. Who knows what will happen, but I think there's very little chance that it's actually implemented before the November election. Now, if President Trump is reelected, then we should have this panel again, because, or actually then we probably won't be able to participate, right, Wes? You're going to have to get European experts because otherwise our assets will be frozen the next day, But if he's reelected, then things could significantly change. But I think if he isn't reelected, if candidate Biden is elected, then then I don't see him going forward with this. But in the meantime, if this were actually implemented, what could the court do in terms of practicalities? I think the court would have to essentially try to avoid using the US dollar, transactions in the US dollar, using the US financial markets, at least in the interim while it's handling the effects of the executive order, and try to use the European currency or move to a different currency. I mean, that is all extremely difficult because of the importance of the US financial system. But practically speaking, I think that's what the court would have to do. And then the court would also have to obviously revisit the list of its staffers and other professionals who support the court to make sure that it's only using those who are not in the United States. That is very, very sad for us here in the United States, but I think that's the reality.
And quite frankly, given the nature of international work, it's going to also involve decisions by people who are not U.S. nationals, but who have family members who are, that would be implicated by this. And I could list half a dozen people that I know who are working for the court but happen to be married to or related to U.S. nationals, where they might have to make some really tough decisions about that. And that's not, the kind of things we want. I also do want to flag, Ezekiel Jimenez just pointed this out, and I saw this right before we went on, but the interim report, which is actually dated for tomorrow, literally just came out from the experts committee. So I have not read it. I have not even skimmed it, but it'll make for some interesting reading during the next week while I'm hobbying up and not doing anything related to work.
Right, and I'm going to make a prediction about the debates related to the presidential election. I predict with a high sense of assurance that this issue is not going to make it into the presidential debate.
We can barely get foreign policy ever into the debate.
Can we expect that there will be a shift, and this is linked, of course, to the question that we've received, that there might be a shift should Biden become president of the U.S. because this is a long-standing, seems to be a long-standing U.S. policy, and so is it realistic to expect such a change to happen? And for instance, well, the question is, do you see restrictions, for instance, I
think Michael's right in that there's not as much shift in this area of foreign policy in between the parties, But I also think that this is a moment that is being seen as very different among the individuals who vote for Democratic candidates. And Vice President Biden is certainly a more moderate candidate than many of the candidates who garnered national attention and support during the primaries that came through. But he's also clearly been more responsive to some of those more progressive perspectives. Now, foreign policy doesn't generate the same media coverage or interest in America. It just doesn't. And I've literally spent the majority of my career trying to educate Americans about why international law is important and has big implications for them. And we still haven't cracked that nut, and I don't know that we will. I am hopeful that at the very least, the worst would be removed. I am not in a position to argue that there would be improvement in any material support or in any kind of recognition. I think we're decades, if ever, away from the U.S. actually ratifying the Rome Statute. That's just not even on the horizon. But I do think it would be reasonable to see either a just decision to let this EO expire, or quite frankly, in a package of multiple EOs that if Vice President Biden were to win the election, I think there's a lot of executive orders he's going to be overturning. This one could be bundled in with very, very minimal political risk. There's so many other EOs that would be far more politically impressive, that including this one as one of the EOs that gets removed is not a significant risk. I'd let someone else answer on the visa questions though, because that's a different element.
Michael, just right before you intervene, Michael, just to let you know that, well, we are rapidly approaching the end. So we will be, I see that there's a hand up. So we will, after your intervention, we will start taking some additional questions maybe from the audience, but please go ahead.
All right, so let me just end this discussion by going back to what I started to say at the very beginning, where I said that I testified back in 1998 before the Senate Foreign Relations Committee. The theme of my remarks was that the United States' best hope for its relations with the International Criminal Court was to be an influential insider rather than a hostile outsider. And I believe that we have seen that's the big difference between the Republican administrations and the Democratic administrations. I think a Biden administration would go back to being an influential insider. They would use the court through the Security Council referrals. They would support the court. They would hope that Americans would be prosecutors and other officials at the court. And they will get more than by being a hostile outsider. And that came really clear. I told the story about the 1999 NATO case, and I didn't tell the punchline of the story, which was because the United States had been such an influential insider with the Yugoslavia Tribunal, that court decided not to indict NATO, but to indict Milosevic. And that made all the difference. And I think that's what we'll see if the Biden administration comes into being.
Oh, thank you. Thank you very much, all of you. I will maybe just add, because the ICC review process was mentioned, and maybe just for the consideration of the panel, what do you think would be the role of Rome Statute states parties in the context of the ICC review process to face these actions, beyond maybe the letter that we saw of support by 66, 67 states parties to the Rome Statute? In the context of the ICC review process, what would be expected from states parties to do in this regard? But before we move in to that question, I will give the floor to Parisa Set. Parisa, you should be able to unmute yourself and ask the question now. Yes.
Thank you. I was basically just asking what this might mean for Americans who have already worked for the ICC or who have interned for the ICC. I think that this has been touched on by a number of you, but also for American academics who might be outside of the US. I think this has also been touched on a bit, but I think that this will definitely have a chilling effect, as you all have noted, and this is something that concerns me greatly as both an American who has interned at a number of these courts and as a PhD student who's writing on the ICC. So thank you very much.
Let me jump in here and address Parisa's question, and I can briefly address your question, Ricardo, as well. But Parisa, basically, the executive order, as we already stated, as of now is bare, naked. It doesn't name anyone. So for now, there's really no risk to anyone. And I wanted to just mention that the executive order has several sections. So section 1 only applies to foreign nationals, doesn't apply to U.S. nationals. Those are going to be the individuals who can be listed as essentially those whose assets, could be frozen. But then sections 2 and 3, which include then individuals who provide all sorts of assistance, if you will, to those who are named in section 1, sections 2 and 3 do potentially apply to U.S. citizens. Now, for U.S. citizens to face any risk, what has to happen first is that the targeted individuals in section 1 first have to be named. And those could be individuals and institutions, as Wes mentioned. So first you would have to name the foreign individuals and institutions in section 1. We'd have to know who they are. Those have to be made public, as I think Wes already told us. And then after that, then you could potentially target, individuals from sections 2 and 3 who could also be U.S. nationals. So as of now, I think we can sort of sit back and relax. But if this executive order starts being implemented, then unfortunately, what that means for U.S. nationals who do work with the ICC in various capacities, including filing amicus briefs or supervising students or providing, IT assistance. What that means for U.S. nationals is they're going to probably have to stop, doing that. And Ricardo, very briefly going to your point about the ICC review process, as we already mentioned, I think this would be a great time for the court to essentially respond to this by improving some of its own internal processes to enhance its efficiency, to enhance its own legitimacy. So numerous individuals have already written, for example, about improvements that could be made in terms of the judiciary. All of the ICC judges are extremely well qualified, but what we've seen over the past several years is that the judges seem to not agree on some of the fundamentals of international criminal law, which has resulted in these incredibly splintered judgments. That should ideally improve going forward. I wish I could wave a magic wand and say, this is how it's done, right? But I think that there could be improvements to the judiciary so that we have a judiciary that's more in agreement on some of the basics. So when it delivers these incredibly important judgments, it delivers them in unanimous judgments where all the judges agree that, this should have happened or this should happen or this is the law, right? When we have these incredibly splintered judgments, I think that undermines the legitimacy of some of those judgments. The other thing that I think could be an improvement is that within the ICC itself, there seems to be very little room for professional advancement especially within the OTP, the Office of the Prosecutor, and perhaps also within the registry. The judges get elected to specific terms. So judges kind of go in and out. But at the OTP or at the registry, from what I've heard, is once people are hired, they just don't leave. Especially if you're hired as like a P3, P4 at a more senior level position, you don't leave. And why would you leave? The Hague is a wonderful city, and the court staff is paid, good salaries, and basically, you don't have to pay much taxes. I'm not saying they shouldn't be, but I'm saying, it creates very little opportunity for professional advancement. And so some of the proposals that have come out more recently include things like including terms like mandates for the OTP staff or for the registry staff, where, for example, you can't work in the same position for more than X number of years. I'm sure that everybody who's currently employed with the court would object to that, but I think from an outside perspective, I think that's actually an attractive proposal. It would allow for the hiring and promotion of younger individuals, but also for more diversity, for sort of, sort of enhancement, if you will, within the professional ranks of the court. And that could all be part of the ICC review process.
And I think critically, Milena, to that point, it's also going to improve the wealth of trained legal professionals with experience in international criminal justice. And this is one of the problems that we're seeing is the consolidation and remediation of several of the courts into residual mechanisms means that there's not as many people out there getting experience, in international criminal justice. And so your pool of people who actually know how to do this is shrinking. more and more and you're getting fewer and fewer people, I think it's perfectly valid. Parisa is right in the comments that there are concerns about people who, about the implication of this on the individuals of folks who just, let's be clear, many of these people in these jobs, this is their life's work. This is what they want to do, by all means. But if I'm 10 years in a junior or mid-level position and I know that there's no way for me to end up at a P4, I'm leaving and going and doing something else at some point. It's just not tenable that you can have someone in the office. I hope, that we could end up in a situation where someone would be 20 years in the same position, as a staffer. And I think that is an issue that needs to be addressed.
And actually, Wes, just on that note, for example, I was recently told by a P5 female prosecutor at the ICC that according to her, she thinks that there are only about 3 women at the P5 level in the OTP. This is a huge problem, but if you don't have limits, if nobody's ever leaving, that means that other very well qualified women, and I would say, racial diversity is equally important, but people can't advance to those positions if those positions aren't opening up.
Yep. Yeah.
Thank you. Thank you very much. I think we don't have any other questions, so I would maybe give the 3 of you an opportunity to maybe make a final comment as a closing remark. If there's any particular thought you want to put forward at this point, because this is certainly a topic that will continue to come forward in the month and maybe even years to come. The presidential election in the U.S. will be, of course, a key element, well, potentially, in how the U.S. policy towards the ICC develops. And so I don't know if you have any closing remarks, any brief remarks that you would like to make at this point.
Here's one I'll say that might stick in people's minds because they like metaphors. I hope a lot of you will know what I'm talking about when I refer to the old cartoon and then the more recent movie with Jim Carrey called The Grinch Who Stole Christmas. That is in essence what the United States is trying to do with the International Criminal Court. It tried to do it with the American Service Members Protection Act. It's trying to do it with the June 10th executive order. Remember what happens to the Grinch who stole Christmas. He stole all the presents, he took it all away to his mountain, and Christmas still came. And the Who's down in Whoville still sang their song, and the International Criminal Court is going to survive this. The Grinch is not going to win. That's my point.
Ricardo, that's a great point. What do I say to that, right? No, my closing remarks would be that although, as we said, the executive order appears to be legal under U.S. domestic law, I think it's terrible policy. It does not promote U.S. interests, and I would argue that actually the U.S. foreign policy interests are with the court because the court is doing such important work towards imposing accountability, towards ending impunity. And the United States itself has supported some of that work. For example, the United States has been generally supportive of the Myanmar investigation. The United States has been supportive of the investigation, for example, into the Lord's Resistance Army in Uganda. And I could name other situations. So I would argue that it's actually in the United States foreign policy interest to support the court, that it's against the U.S. interest to try to undermine the court, and that this will actually backfire. It will erode the U.S. position in the international global arena, and it might end assistance that the United States currently receives from other countries in other initiatives, including, for example, counterterrorism.
And I'd just build on Milena's point and say, in that policy sphere, the Prevention and Protection Working Group and other NGOs are working very hard to try and engage with the U.S. government through different systems than the International Criminal Court to try and move the cause of atrocity prevention forward. And I think, every international criminal lawyer and international criminal justice person out there is also a strong subscriber to the idea of atrocity prevention. Like, we would love to put ourselves out of a job. We would love to not need these kinds of mechanisms, either because they are dealt with at the national level first, or because we, as a human race, start recognizing that it is in our collective interest to try and prevent these kinds of atrocities from happening. And so there are many ways for you to get involved. You don't have to find a court to work for. You can find organizations that are trying to help in transitional justice ways and in atrocity prevention ways. And I would encourage each of you to go out and find those places where you are and contribute your time, your expertise, your knowledge, just your enthusiasm can make a huge difference.
Well, thank you all. I think no matter how dark the current context looks around the ICC, I think this panel really gave hope and clarity on what to expect, but also it allowed to understand more what the executive order means and what the implications of the executive order may be, and how the court could, through specific measures, be protected and strengthened so that this doesn't mean the end of it, but rather it becomes stronger and more resilient than it already is. So I thank you all for your participation, the attendees for their questions, and the panelists, of course, for all their views and the time. And we hope to have more conversations like this as part of our global exchange in the future, hopefully in a more promising future. So thank you very much, everyone, and see you next time.
Thank you.